Yeah, good morning. Our comparative analysis revealed three main approaches that use company law or financial and securities legislation as a tool of corporate climate litigation. The first approach is based on provisions that require companies to disclose information, either information related to the financial risks associated with climate change or about their greenhouse gas emissions and the steps taken towards climate neutrality, such as the duties under the CSRD and the CSDDD in Europe. These provisions aim primarily to ensure transparency and accountability and to enable investors and stakeholders to make informed decisions. In the case of undisclosed or incorrect information, many securities laws provide for liability for damages caused to investors in the securities market. And this can then be the basis for compensation claims of private investors, especially in greenwashing cases, which have a relevant effect on the stock prices. Even greater pressure could be exerted by a personal liability of directors due to inadequate measures addressing climate-related risks. In basically all jurisdictions, directors of a company are under a duty to act in the best interests of the company. With regard to climate change, this means that directors need to adequately address and mitigate climate-related risks and may be held liable for making decisions that harm the company's long-term sustainability. However, many, if not most, jurisdictions provide for purely internal directors' liability, which can only be enforced by the company acting through other directors or a supervisory board, and which is not open to climate activists. This means that corporate climate litigation requires provisions stipulating an external director's liability towards third party. And this is only known in some jurisdictions and usually under special circumstances. The third avenue for climate action using tools of company law is what we call shareholder activism. Shareholders increasingly use their ownership stake in a company to advocate for specific changes in corporate behavior. And to do so, they try to turn the shareholders meeting into a forum for climate-related issues by filing resolutions, by filing agenda addition requests, or by demanding a say on climate. Of course, in some jurisdictions, shareholder action goes well beyond that and includes legal proceedings in courts to hold the company or its directors liable, but that usually uses the other tools I just mentioned. To summarize, company laws and especially financial and securities legislation can, in principle, serve as a basis for corporate climate litigation. But the governance structures and requirements for specific claims differ greatly in the individual jurisdictions we examined. And here, I think the national reports can serve as a great basis to go further into the details. Thank you very much for your attention.